Good afternoon, everyone. Welcome to the Historic Town of Eatonville Community Redevelopment Agency meeting today, Thursday, June 20th, 2020 at 6:30. Okay, call to order. May we have the roll call, please?
Yes, we have Director Gardner.
Here.
Director Washington. Director Pritton.
Present.
Director Mack.
Here.
Director Daniels.
Hello.
Vice Chair Williams.
Present.
And Chair Randolph.
Here. Let's all stand for the invocation and pledge allegiance. This moment will be a minute of silent meditation at your pleasure. Okay, all is well. Pledge allegiance. Okay, thank you very much. At this time, we will have presentation.
Do not see anyone here from Fort River Smokehouse, so we will deliver the certificate as well as the census.
Okay, thank you. Next item is citizen participation.
Yes, our first one, we have Joyce Arbit, who come to.
I'm moving to,
You're yielding to?
Kathy.
Kathy, okay. The next one would be Kathy.
dressing the staff, CRA, good evening. First of all, I've been to many meetings many times. My name is Kathy Mills. I live at 318 Greensend Street in Catalina Park. I've been a citizen of this town for 44 years. My problem today, and it is a problem. I was not here at the last CRA meeting. There were several people that came and spoke against what I'm asking to have done from the town of Eatonville. I received a text message this evening letting me know that someone from the CRA board contacted them and asked him to come to speak against me. They know who they are, so I'm not calling any names. I respect that, and I hope they do too. But what I'm asking for the CRA staff to do, my grandmother, Rita Latimer, that lived at 41 Lincoln Avenue, passed away some years ago. What happened was my son was Will and his aunt, but two of his aunts, which one is deceased now, was left the home. We have worked to keep up that home. Lies were told that that house needed to be condemned because there was no water there. That's not the problem. They have water there. What they don't have is a septic tank that's working, or they have not been connected to the city since the city connection. All we're asking for is that the CRA grant us that funds. It's not a big fund. It's not as if we're asking for you all to help us from 1970 to 2024. All we're asking is the pipes to be placed and connect that home to the city. in which she lived, in which she paid sewage for and didn't get sewage. She had septic. From 1970 to 2024, is that too much to ask the CRA for? I don't think so. And another thing, we were downgraded in front of this whole meeting. But she forgot to tell this whole meeting the reason my son wasn't able to move in the house when it was available. She moved her daughter into that home and out of hers. And the reason her daughter had to move out of this home is because the town of Edenville Police Department busted it for drugs, from which her daughter and her daughter's boyfriend lived in. So don't look down at what we're trying to do. My son, he's on dialysis. He's on a fixed income. I'm retired. I'm on a fixed income. I feel like at least the town can do that much because I am a giving person. I try and look out for the citizens of Edenville. I deliver food to people, but now all of a sudden, I'm not able to do that anymore because someone from this board has put in a word for me not to be able to do what God had me to do. And that was to try to feed the citizens of Edenville. But I'm going to find a way because there's a lot of hungry people out here. And there's a lot of citizens, senior citizens that need a lot. I don't know if anybody on this board forgot how they got here. How did you all get here if it wasn't for the people out there electing me to be here? Did you ever stop to think about they may need some food or water or a drink or just a plain old conversation? How many of you all have done that? I don't think so. So I'm asking, and I don't usually ask for anything much. I'm more of a giver than an asker. But if you all could go ahead and consent to help us get this done, I would truly appreciate it. Thank you.
We have Nia Brown.
How you doing? My name is Nia Williams-Brown. I'm a constituent of Edenville as well as vice president of 18 Center First. And we actually have a exciting multi-layered solution for the needs for the residents of Edenville. As we heard Ms. Kathy Mills speak about, the people of Edenville need food. We need sustainable food, not just chips and junk and things of that nature until we get back to the historical character of agriculture. Then we'll use this as a vehicle. We look forward to your support, and I'll also be sending a sponsorship package to the board. You all have a beautiful day. Thank you.
Thank you. We have Mr. O'Hara.
Well, staff, my name is Nicholas O'Hara. Spoke toward some of you the other night at the Tuesday meeting, but to those that weren't here, again, I am a 44-year resident of Edenville. It's my home. And I saw that meeting. And I saw some of you guys mention my name and spoke that we need to come speak with Nicholas. That meeting was May 31st. No one has still came to speak to Nicholas. My mother has been coming down here. And you guys have voted to help me, to help our situation. But then this woman was able to come from Apopka and speak at our Edenville town hall meeting and speak on Edenville citizens. That pays his water bill, that has water that house doesn't need to be condemned, but has been getting money taken from our family since 1965 by the town of Eatonville. We didn't come in here rah-rah. We didn't come here say, y'all, oh, it's this and that and this and that, or else it's this and that. No, man, we came here with our heads tucked, humbly asking for some help. And now I gotta come down here because I'm not gonna see my mom in tears every day about this. Sorry. We shouldn't have to go through that. We shouldn't have had to go through that. And I hope they'll fix it. I hope you guys fix what you started to do and do right by one of your own. I brought 1887 Entertainment here. Look it up. The first legitimate record company in Eatonville. It's my home. It's tag on me. And I'm glad for all this. Y'all know how Eatonville people do for Eatonville people. Thank you.
We have Angela Thomas.
Joy Thomas, from Zone Park Street. I am calling speaking on behalf of 41 Lincoln as well. After I did speak on the 31st, I got a call from my ex-husband that one or two of the council of the directors called him in regards to me. If you want to talk to me, I'm real available for you. But what I'm here to say today is the property is in the name of Wheeler Lattimore Estate. My son and I did go downtown about 2 weeks ago to pay the taxes on the home because it was not paid. Come to find out, we couldn't pay the taxes because the tax certificate was sold on May 31st. If you'd done your research, you would have saw that that's done. I'm asking that you let us handle this as a family. We try to get it resolved. And if we can get it resolved, then we will bring it back to you guys and let it happen. But as of right now, we're trying to get the tax certificate paid. It is $1,300.
It's paid.
It's paid.
I do have the money to pay it.
It's paid.
It's paid. Go to the
Do
next.
your research.
Do your research. It's paid.
Yeah.
Do your research.
It's paid. I'm sorry.
This advice.
Go home.
And it's in my name.
This information, we did get it from the clerk of court. From the appraiser. He told us that it was not paid. The certificate has been
So
sold.
we got receipts.
We do have to pay $1,300 to get it done, but allow us to resolve this as a family. If the director, which I'm sure he know who he or she that I'm speaking about, if you want to talk to me, come talk to me. But my ex-husband has nothing to do with how I speak out on it. Thank you.
I would like to comment, and that is outbursts in this meeting, were not tolerated.
Yes, ma'am.
Thank you. Okay, let's proceed.
That was the last one.
Great. Thank you, Mrs. Stewart.
Can I ask one thing before you go? Is it possible that we can switch 7 and 8 board discussions and board decisions so that
Which one?
section 7 and section 8, can we just switch those?
She's requesting to move the decisions, can we swap out 7 and 8.
Decisions first and then
Okay, I got you. Oh, you want to, I see.
I'm just asking.
8 and 7, you want to reverse?
Yes, yes, 7 and 8. Okay.
Is that okay, mutual for everyone?
We can do a discussion on this, because it said approval, it's saying two different things. It's saying board discussion, then these saying approval reimbursement related fees. So
It's a
we're,
discussion.
It's still a discussion.
It is a discussion.
so if I said approval. Go ahead.
Can we switch the two
You
sections?
switching up, you're saying.
Yeah, we don't.
Does the board, Attorney Jackson, do we have to take a vote or we're fine to change the order of the agenda?
Yeah.
Unless it's refund it.
Go back to Cicely. You wanna switch?
Don't do that.
Excuse me, I'm sorry.
We have to have these phone calls.
Excuse me, please.
No problem.
We have to have order. If there's another outburst, I'm going to ask you to leave. Okay,
Okay, I'm sorry.
all right, thank you.
So for the record, our consensus of the board with switching.
Okay, we're gonna, reverse, number 7 and number 8. And also, we have an add-on that's in front of you. Opening and develop the employment status, CRA Executive Director as a walk-on.
For the 7.
It should be number 4 because it'd be for discussion.
Okay. All those in favor? On the change? Motion to the changes. Yeah,
There is another add-on
there's another add-on.
that is for the legal fees.
I thought it was already.
That's going here for discussion too.
Somebody,
You talking about the additional documents? So this is already on the agenda.
It's already on the
It's under
agenda.
discussion, which a discussion item can be
Okay.
a vote could take place in a discussion.
Okay.
we have a motion to approve the changes on the agenda, please. Second. It's been moved by, board member Washington and second by board member Mack. All those in favor? Aye. Any opposes? Okay, motion carried. Thank you for the changes. Okay, now we will have the consent agenda, approval of the board meeting minutes. You have that in front of you. And the approval of the consent agenda. So, is there moving second, proper second? Discussion? Okay. All those in favor? Aye. Any opposes? Motion carried. Okay, now we're going to board decisions. Is that correct?
Yes.
Okay, number 4, approve the resolution. 2024-24, Mrs. King, when you read the preamble.
Yes, resolution CRA-R-2024-24. Resolution of the Board of Directors of the Town of Eatonville Community Redevelopment Agency, TOCRA, approving the contract with GAI Consultants Community Solutions Group for professional planning services for Eatonville CRA plan. Update in the amount of $50,000, providing for conflicts, severability, and an effective date.
Okay. You have heard the preamble read. May I have a motion, please?
Second discussion.
It has been moved by board member Daniels, second by board member Printon. All in favor?
Questions?
Discussion.
My only discussion point is in regards to the amount. I know that we previously budgeted, I think 25, correct me if I'm mistaken, for updating the plan. I see that the scope of work was included. Can we just explain how we doubled in cost potentially?
So this is to include, so the CRA currently expires in 2027. So this is the additional funds are to include the conversations, both here at the town as well as on the county, and going through the county process to get an extension for the
And it requires an additional $25,000 to do that.
The consultant is available if you all like that.
Big increase.
My name is Tom Kohler, Senior Director with GAI Focus Community Solutions. I don't know where the original $25,000 figure came from, so I have no idea. All I know is what we're seeing, what we've done with our proposal is put it in two different. It's an hourly rate up to $50,000, and the first part, as this Rose indicated, is negotiations with the county, because you have to get county approval because they are part of the county. If they decide that they are not going to extend the time frame, then there's no reason to update the CRA plan. We're doing this right now for Winter Park, Ocoee, and Kissimmee, going through the same procedure. So I have no idea where the first 25,000 came from. We would never have done it. It's not a $25,000 job. I think you're getting it, honestly, because we did the 2015 plan and it was never adopted formally.
Right.
So we have the advantage of, streamlining that process. And so we think this is a legitimate opportunity, again, because we're doing it on an hourly basis, not a lump sum. So it's however it does it. That's what we're experienced in doing. So
I don't have the formally adopted budget right here in front of me tonight, but Director Rose, would you happen to know what was in that line item that we approved? I know this was prior to your appointment as the executive director.
I didn't know that there was anything in the budget set aside for the plan, and I don't think that was, because I don't think anyone had consulted with GAI. Most recent months is the first time that Tom Cole and I have had the conversation to update. So if that was in the budget, I didn't see that in the budget, and I don't know where that number would come from.
And I mean, you all can chime in when you're ready. This was a discussion that was had prior to, of course, hiring Director Rose. I believe Ms. Bonds was sitting in as administrator at the time, where we had discussed getting the plan updated. Of course, I'm green in that area. I couldn't tell you how much work goes into that or what the value of that work would be. I'm just noticing what I believe to be an increase in the amount that we had allotted to do so, especially considering that the 2015 had been previously constructed, just never adopted. So I might have been forced, or I might have been stepping over myself by believing that we could kind of just take a look at the 2015 that was never adopted and then compare that to the 1997. I do know that even with the sunset approaching, that it is imperative that we do update the plan because it affects how we work, right? If it's not in the plan, we can't do it. So regardless of when the sunset is, I do believe it's something that we do need to take into immediate and urgent consideration. I just was hoping somebody else could chime in and maybe explain the need.
I got a question. Did the county approve the 2015 plan?
It wasn't.
until you have to put it forward. So it was adopted here.
So we're still working on 1997.
You're working on that.
So what I'm trying to understand, GAI did work for the CRA in 2015. And the town, I guess we never adopted your work.
No, we tried, we never got it approved.
So therefore, we back to the.
So did you get paid? I'm just asking.
Yeah, well, remember, we had a contract with the Winter Park.
Okay.
Foundation.
Okay.
And we were paid by them,
Okay.
but there was no formal adoption. We went through, the CRA moved it forward to the local planning agency, LPA, which was your planning and zoning, if you recall. I have a history there. You didn't even have a planning and zoning forum because the meetings were, you didn't have, they were vacated. There was nobody. So we actually got those appointed and then the LPA approved it, but it never got formally adopted.
Go ahead.
So I don't remember exactly with the 25, but that definitely would have been before, GAI, because the interim director. And I don't remember where the 25,000 came from, but we knew we needed a plan updated. Which brings me to my question. The plan was not submitted. And that came out in like 2019, that they had never received the plan. I think it was around 2019, 2020, but they realized that the plan had never been submitted for approval. And even though that's been several years and things change, if it was never submitted for adoption, then it was never not approved. So my question has been, why would we not just kind of tweak it and then at least submit the plan? Because even if we do not get sunset, we still need an updated plan. Even if they don't extend it past sunset, we still need an updated plan. So does that make sense?
And that was kind of my sentiment as well. If they have done some preliminary work, I know that we had some preliminary discussions about kind of like we did with the bylaws, taking the old, looking at 2015, comparing and contrasting, seeing what we wanted to keep, what we didn't want to keep, and moving forward with submission. So I would hate to ask them to do the same work all over again. But I mean, it needs to be done regardless. So I'm in agreement with that. I was just kind of hoping for some additional clarity. And then Director Daniels was able to pull up a document that was submitted to the board back in about September that outlined $25,000 under proposed projects and programs for the plan update, roughly $25,000 that we had approved. Of course, we do have the authority to make that amendment, but just considering that we had already started with something, if it's necessary to adjust that, then I'm in favor of that, simply for the benefit of the agency. But if it's not necessary, then, I think it warrants a discussion at minimum.
I mean, me personally, I think we need to clean our house up a little bit before we go out and hire anybody doing the work. I mean, I didn't know anything about, I wasn't here at that time about that budget amendment or what have you. That's just how I feel. We just need to come together on some things, make our suggestions as far as going forward on the plan update.
One of the things I would
Before
say,
we have them submit in that. And I think some of the stuff I looked in here for them going to talk for us. I'm like, hold on now. I mean, some of the stuff I feel like we can do ourselves, with the rapport that we may have with the county itself, just to reduce the cost of that standpoint. But that's one person, but just tell you how I feel. So.
Ms. Rose, what was your comment?
so the bigger picture is there are some things and some grants and opportunities that we want to seek, but they're not in our plan. And so what we've got to be careful of is kind of stretching what does exist to do the things that we would like. And we do need a detailed plan. And that's the reason I would say this: you hire professional services to do professional work that they're skilled in. And so GAI in the region, number one, there are a few things. They are hired. One of the things that we are allowed to do is we're allowed to piggyback of Orange County, and they are the consultants contracted with Orange County. The other part is the other regions have been successful in getting over hurdles with ensuring that their plans get extended. And so that was the reason for reaching back out to GAI. The other CRAs use GAI for their services, both from planning, and I would say the other municipalities, in totality, specifically CRAs. Winter Park just got theirs approved, through GAI, and so that's the reason for seeking GAI services.
I do believe that time is running out. So if we can just flip it then, if we can seek to get the extension, I think you stated that in the beginning. I think Mr. Kohler said that in the beginning. The approach for the extension, get the extension, then the submission.
We can't get an extension without an updated plan. So because we have to present to the county what we're trying to do.
Then it goes to reason if they have not reviewed that 2015, which is my understanding, that we tweak it to be not so stringent that we have to fit everything on the line. But but lenient enough that it will help us get done what we need to get done. That'll save us some money on an updated plan for them to review. If they have a problem with the plan, then they'll let us know. Right? So if you submit a plan and they don't approve it, they'll tell you why they didn't approve it. We can tweak it for those items, and then we can go for the extension once we get the approval. And my other thing is it up to 50,000 or 50,000, that's it?
Tom, is it up to 50,000?
It's up to 50,000.
Up to
Yeah.
50,000.
And we broke it down into two things.
Yes.
Yeah.
That's all.
Once we sit down with the county, with your staff, and if they said, this is what the criteria you're gonna need if you're gonna get our approval for extension. That's what
Right.
Winter Park and Ocoee have done as well. But if they say, hey, no, then we're through.
So at this point, we don't know until you meet with them whether or not we'll be granted an
Yeah,
extension.
they have some criteria that you have to follow. Yeah, so, yes.
So, I mean,
Kohler,
Yes.
the other municipalities, are they all in the same ballpark, 50?
Oh, no, much higher,
Much higher?
yes.
So for our demographics and our.
Yeah, no, much higher, but it's significantly higher.
And your company is,
Well, look, I've been in this town, I've done a lot of pro bono work in this town over the last 40 years.
I remember.
Right. This, part of it is just the discount of having us here, because if you have to go out with another firm, and I'm not trying, if you don't need us, that's fine, I'm not trying to, but if you have to go to another firm, they have to start all over. And it'll be significant. So, anyway, that's all I'm saying. If you don't need our services, that's fine. But we feel very strongly about supporting Eaton.
and according to the executive director, GAI is over the other municipalities, Winter Park, Ocoee, you're all in, so I'm asking this board, I'm in favor of it. I know it's a lot, but we gotta get it done.
I have a question.
Yes.
So 97, we got it. Who did that one? The GI did that? The 97 plan?
Let me look and see, because it should be on the bottom.
I'm just asking a question before we.
The song should have been established already before even coming to this meeting. And we did it in 97, we did it in 15,
15 and then get.
moving forward,
Yeah,
you
15
have a
hasn't
better
been approved
idea
yet.
of what we're dealing with.
But my other question is, I got this compensation form here, y'all have the paper?
Yes.
So it's saying part 1 and part 2. So it's $74,000, 7450. So that's what they'll be getting.
No.
What's this year?
Things have changed, and I can email the updated so some of that we've taken out, and I can send you all the updated that I just received, that breaks down to 50,000. That was the original, and then I negotiated with Tom and told him this is what the $50,000. So we had a further conversation. The original plan was done by Commonwealth Engineering.
We're in charge.
Oh, I'm not sure. That's 1997.
I'm just saying, she found that, she probably found the numbers too. You know what I'm saying?
You know, I like the idea of tweaking the 2015 plan because it's a more of an upgraded plan from the 1997.
Oh, it's significantly different. Yes.
So I think that would be an excellent suggestion that I think that would work. And that would kind of get us up to where we closely need to be for this day and time. So if we can do that, I think that would be a plus in our cap.
My question is, if we have that already, staff should be able to get the number of payments or whatever is in that plan, we have a workshop, whatever, and say, hey, this is what we're gonna go with, take this in, take this out, or add this in before we, like I said, we don't have the original copy of the 74,000, you saying 50,000, and we finna vote on something that we don't know what number it's gonna be.
Yeah.
So I
Do
don't
we
think
have-
how it's gonna
yes, yes. Do you have a deadline that you have to meet with the county?
No, it's your deadline.
It's our deadline.
it's okay. We're not talking about the year ago,
Yeah.
extension.
So there's a few things. So the amount of 50,000 is up to, and so of course that it could potentially be less based on the hourly wages. This process is gonna take 6 to 9 months, and so that's why we're starting it now. To kind of make sure we get through everything we need to as far as updating the plan. So what is included in the price is because you just mentioned tweaking the plan, that is there. There's gonna have to be some conversations based on so there's research that has to be done, which is why the cost seems to be high. We have to look at GAR has to look at different variables as it relates to the projections, because that's part of the plan, looking at projects, evaluating things. Am I correct?
We have to update all the increment projections. And you're unique, and you're the only, I think, 1 or 2 cities, towns in the state that the entire town is a CRA.
Yes.
So that's the other.
That's something that we can take out. That's what it was talking about. We can take some of that, instead of the whole town. We can.
No, that's a whole nother.
It's all not that.
Another camp.
It ain't updating the plan then.
Yeah.
That's not updating the plan. They keep the plan the same. We can't take that out.
Yeah, right.
You know, so how can we fix that? We can't take it out.
Well,
You can, but it's not, you have to follow chapter 163, and your town attorney will support that effort. I don't think that's a heavy lift. It's just a process you have to go. It's a legal process you have to go through. And then you have to decide what your new boundaries are. And then we have to get a legal description of those boundaries. So I'm just trying to be very frank with you.
yeah.
So
So what is the pleasure of the board? We want to review the 2015 plan to tweak it and make a decision.
I mean,
I will support that part of it. Get
Pardon?
2015 plan.
Yeah.
Updated. Yeah.
I would like to do that as well. I think we would have, since the whole town is the CRA district,
Yes.
I would encourage the citizens to give us their input as well. Just to see, as a whole, just to keep everyone inclusive. At the end of the day, we're supposed to be community service, so I think we need the support of other people as well, in some way.
Yeah, I can agree more.
Just going forward. Since try to do it in some kind of timely fashion. That's, we'll get with other director on that far, set some kind of workshop or whatever, so we can get their input as well. And, just move forward using that 2015 as the foundation for the new update.
I agree as well that I feel like we should, maybe bring this back for discussion. That way we have an opportunity to get everything out on the floor. If you refer to your emails from June 15th of last year, Ms. Washington did send out a copy of both. I would probably ask that, Vice Chair, as well as Director Mack, Vice Chair Williams, as well as Director Mack get a copy of that. I need to forward it to you, I can, but they did put them side by side so that we could kind of read through them. I do like the idea of the 2015 being a foundation. There were some things that stood out in the 1997 that came up for discussion after we had this conversation that were important as well. So for reference purposes, just so you can kind of compare and contrast, and then we can bring it back for one another and have an open discussion about it. And then decide if what route we want to take. I mean, because I do agree that it's important, especially with sunset being in just under 3 years. And I'm not strung out on the dollar amount, but I just want to make sure that we're not doing anything that we don't need to do, and that we're considering all the resources that we have available to us. So if it's the board's pleasure to maybe table it to a later time, I think that's what I'm hearing. I don't want to speak for the board, but that's my opinion.
Yeah, especially with, Vice Chair, myself, this is new news to us, so we definitely want to sit down and, apparently, look over everything and have, strong discussion about, everything that's, in front of us to have, a better educated decision on the direction that we're gonna go at. So we definitely need to do, especially with the timeline coming with the, extension of the CRA, which is something that I think we need. We can not have it, right? But we need it, I think, for the purpose of this community. So
Okay. So do we want to move to table?
yes.
Okay, well, motion to table?
Wait, Have to rescind the vote that's already on the floor.
Okay,
Then I'll rescind my second with discussion.
rescind, okay, the motion has been rescinded. And it has been second. All those in favor?
Aye.
Aye. Any opposes? Okay. Now, what we wanna do is, what do you wanna do with this
Table it,
contract?
bring it back for discussion.
Now we wanna move to paper this, right? For what, a workshop or?
Get the workshop.
Okay, we wanna table this item for a workshop.
Workshop.
2015 plan.
Some citizen participation.
Do we have a motion?
So moved.
So move, second,
Question, just a statement.
discussion.
You know, when we talk about citizen participation, we have stakeholder meetings now, we have action planning meetings and citizen participation as well. That's not to discount citizen participation. But if what I would like, if we're gonna workshop it, that's gonna get the set dates that we're gonna workshop and have a timeline when it's gonna be finished. And I would like for our planner to be a part of it because a lot of these elements in updating and extension, I think it's over our heads. You know, and some of the things that we are saying, I don't think we know enough about. And I believe that an expert should talk to an expert, so I would like for her to be a part of it. So that we understand it.
Yeah, I think that's maybe in the process, because I know here on page 18, it mentions about coordination meetings, etc. So you'll say that doesn't have to be inclusive, or it should be inclusive of our stakeholders. The other meetings that you mentioned.
Well, any workshop they have is open to the public,
Yeah.
but what I'm
Right.
saying is, we can get public input, but if we can't guide what it is essentially that's being inputted, what we're asking, then it's not gonna be very effective. So we do need at least our planner there to help guide that whole process.
Okay. It's been properly, go ahead, I'm sorry.
I was just saying that she did recommend that we put a date on it. I was trying to pull up when the next stakeholder meeting is. Do you happen to know?
Like 25th,
It's the
25th, something.
Of
This
this
is the
month?
fourth Monday.
Okay,
Thank you.
so that would be Monday's coming.
Okay, it's been moved and properly second that we table this item for the 2015 plan pending a workshop. All those in favor?
Aye.
Aye. Any opposers? No? No other discussion? All right, thank you. Motion is carried. And Mrs. Rose, can you set that up for us for a workshop? Thank you. Okay, next we have approval of resolution CRA 2024-25. This is King.
Resolution CRA-R 2024-25, a resolution of the Board of Directors of the Town of Eatonville Community Redevelopment Agency, TOCRA, Eatonville, Florida, Board of Directors approving a funding agreement for the paint, plant, and pave program at 427 March Street. In the Park Street.
I saw that misprint on it. Where's Park Street, Mark Street.
Park Street in the amount of $1,400, providing for conflict, severability, and an effective date.
Okay, you heard the preamble. Is there a motion?
Second.
It's been properly moved and second. Any discussion? I have a discussion. Okay. This particular project here. I have a couple of things here I just want to point out. And that is just to ensure that when we accept packages and applications from individuals that they're properly filled out. It's just a minor issue, but we just want to make sure that when we, I'll give you an example here. The application on your page 34 from the applicant in your packet, it doesn't have the project description listed on the form. It's just a minor thing. And also on the next page on 35, the applicant's name needs to be in that claim. And the reason I'm pointing this out is because we have to get conditioned to make sure that when we accept papers and we accept applications from individuals, whether or not they get a job or whether or not they're filling out for improvements, that everything is filled out. Because a lot of places it's unacceptable. Even if you make one mistake and don't check one block, I have seen this many times, hundreds of times, that your application and your paperwork it just basically be put to the side. So we don't want to lower the standards and have people, and I'm not saying this particular person, but having individuals just to fill out paperwork that's missing information. Just want to make sure that we have the accuracy in our system, in our processes, so that way we can be accountable to the people and also accountable to the process. So I would just say I will vote for this, but I'm just saying if we can get with the applicant and maybe just have those two particular things just kind of filled out, just a matter of just writing something on here, and that way it will be the correction. Okay.
What was the total? What was the total?
The total so far is just $1,400.
I see all the bids in here or something.
Yeah, and the corrections have been made from 427 Mark Street to 427 Clark Street. So we can just verify that and just kind of make sure that's
On the house.
fine.
Okay, on the house.
Okay. All
That's
right,
jumping.
are we ready to vote? Okay, all those in favor? Aye, any opposed? Thank you. Motion carried. Okay, next we have Resolution 2024-26. Moving and updated bylaws. Okay. 16, read the preamble, please.
Resolution CRA-R-2024-26. Resolution of the Town of Eatonville Community Redevelopment Agency, TOCRA, repealing the existing bylaw and adopting the following bylaw, providing for conflict, severability, and effectiveness.
So I'd like to make one correction. So under section, and there is a opinion that I can share with the board. Under section, and so full disclosure, these were items that this was put together based on input as requested from the May meeting. Under section,
What page first?
I'm on page 40 right now. I'm trying to find where. Under Article 3, section 3.1, members of the board, there's a section that one of the directors requested the town council may elect an independent board of directors. There is a legal opinion that is not allowed, so that entire section must be stricken out of section Article 3.1. So the section that reads, the town council may elect to appoint an independent board of directors of at least 5 members, but no more than 7 to serve on the board of directors. If this method is chosen, the membership must be consistent with Florida State Statute 163, Part 3, with appointments required by the taxing authorities as per the stated in a local agreement. That section must be removed based on legal opinion. We are not allowed to have an independent board, and I can share that with the board of directors.
Yeah.
Am I correct? Okay.
And they all already have a copy.
Yeah, we got the copy. Got the email also.
Yeah, so just letting you know that part has to be stricken out of Article 3.1.
Okay, what we're gonna do with this one here is that we're gonna go ahead and give you the chance to put a motion so it can be further discussed.
Okay.
Okay, so we need a motion on CRA 2024-26, the update CRA bylaws.
Chair, before we make the motion, I'm sorry, I don't. When we first talked about the bylaws, we said it was gonna be a workshop. And that we asked everyone to me, it seems like it should be redlined, you know, what's changing. Because it was my understanding that it would be workshop. So everyone submit what they want to be changed and considered, and then we go for a vote. This was a lot to try, and there are some contradictions in this, like 2.9 to me contradicted with 2.5. There was just some, I thought it'll be a better document if it's workshop. That's my opinion. And also in regards to the opinion, for those that might say an opinion is not a court ruling, whether it's an independent board or not an independent board, I don't think it's CRA's power or authority to make that decision. That will come from the council side on how the structure of the CRA board would be. That's my understanding. And that's how it was when it was first made an independent board. That's not something that you can just put in the bylaws and say, this is what we're going to do.
Right.
So
So that was the other piece of what you just,
I have a question I have to ask. Okay, thank you. Who wrote this resolution?
It was from input from several of the board of directors.
Okay, and was it vetted by Attorney Jackson?
It was presented, it was provided. And then that's when I asked about the legal opinion as far as it relates to the independent board. But it is my responsibility, if a director presents something, that I need to present to the board as is, and then the attorney would make adjustments accordingly.
Do you make the adjustments?
Yeah, I pointed out some issues with the bylaws. But if it's gonna be workshop, then I think that that's the appropriate place to do that, because there are a number of areas that I was gonna mention some issues.
Yes, that's usually the way it's done. We usually take the in fact, we just did an update, we just amend the new CRA bylaws last summer.
Well,
June.
15th of that fact.
Yes.
Same.
Yeah, so we just did this during the summer, about a year old right now. So we did like a 1 or 2 little twinkling changes. So when and I agree, when we do these changes, you have to have both of them, so we can see what the difference are. And I can see there's a tremendous amount of changes, that things is not included. It's not inclusive of the one that's being presented from the old one that we have here. So I think we need to go back to the table. And yes, we do probably need the workshop, yes, to the table.
So we're gonna put in a motion to table, or
Yes.
you never got the chance to,
Rescind the motion.
I mean, you never got a chance to, they jumped the gun. You can get
when
out.
I tried to stop it before the motion, because otherwise you have to rescind the motion.
Right.
It didn't make sense to do that. That's why I
Okay, let's
apologize.
go ahead and put the motion to table, or do we have to? Okay,
Okay, but motion to table.
so moved.
So moved by Board Member Clinton, second by Vance. Okay.
I have two bylaws, and it's the same ones. One of those.
Yeah, one's a resolution and one's the actual bylaws. They have to be separated.
Okay. All right, are we okay? All right. All right, we need to vote. All those in favor?
Aye.
Okay, ayes? No opposes? Thank you. Motion carries. Okay, and the next one is the reimbursement of legal fees. Mrs. King, the big round, please.
There is no pre.
Okay, yeah.
This is a discussion item.
So can I jump in? I guess I'll jump in.
You don't see that.
Some other.
I can't talk about it.
Whatever. So it was supposed to be in both the town council and the CRA agenda, though I wasn't sure at that time where the discussion should lie. But based on Tuesday's confirmation by Attorney Shepherd, the council, based on the laws, would make the decision about the reimbursement. Because the CRA can't make the decision about money spent on the town side. So I'm assuming based on the law that the funds have to come from the town. That's how the ruling was, and not the CRA fund.
That's my understanding.
Okay, so that being the case, then the reason that I think is significant to have in this meeting is because it lets people know that an investigation was done, an ethics investigation was done, and there was no probable cause. So hopefully we can put this to bed, and you have all the documents that I have in regards to the actual amount. Part will be reimbursement, and there is an amount due now. But, if that amount is, if that balance is gonna go past, 3 weeks, then I'm gonna go ahead and pay it and I'll ask for reimbursement for that, because I don't want the attorney to be waiting for his money based on what we're going to do. So the documents are there. You'll see confidential written on them. These documents I provided. We talk about transparency. Here they are. Here they are. And the one thing that I would like, just for my satisfaction, a lot of this ethics complaint was based on the resolution that was submitted. And I would like to know who prepared the resolution. Because had the resolution been written properly, then it would have spelled out how that whole termination would have flowed. So I'm asking Chair, you could share who wrote the resolution, where did it come from?
Let me take a look at it. While I'm looking for that,
One good for that. I was investigating too, and it was not fun. So we don't want to worry about the check signature thing. I already been through the process
well,
with no legal fees. So I would love to get legal fees, but I'd have to go through that process.
well, the way that, I know this process seems to be very confusing at some point, because first of all, the contract was not legal. Okay, and based upon the write-up from the Tallahassee authority of the Attorney General's office, the public purpose for this was not done in this case here, and I'll have Attorney Jackson explain that. Then for the resolution, Attorney Jackson was involved as far as the resolution, and all the information was provided. I provided a lot of information and the documents. So when you say that the resolution was a problem with the resolution, what was the problem?
So you had to turn for that. You had to.
So the original resolution you're saying was done by Attorney Jackson?
Yeah, I provided a lot of the information to go along with the resolution. So when you say a resolution, I mean a resolution, you say the original?
The resolution that was acted upon.
Yeah.
I wasn't here at the time.
Was it, you were here?
No, man, I wasn't here at the time.
What's the resolution date? I'm not too sure.
It's
Was
the
there two
resolution that you
resolutions?
submitted in your packet.
I have to see exactly what you're saying.
Findings with the state.
The resolution that you submitted in your packet in the ethics complaint that signed was the resolution that was placed on the agenda for the vote.
And that would have been Attorney Perry that was here at the time. I wasn't here.
I'm asking who prepared, I don't think it's attorney.
Cause yeah, I didn't see that.
When I came on board, Perry was here.
Well, I'm gonna clear it up. I'm pretty sure it wasn't Attorney Perry. So I'm asking who prepared the resolution. It wasn't Attorney Perry.
Or it could have been the town clerk at the time.
Oh, that resolution,
Yes.
that was done by the town clerk. Miss Cat.
This is what you're talking about. I don't know if this.
Yeah, she prepared the resolution.
That would.
That was, yeah, the town clerk.
She did a good job.
It acted on a resolution that wasn't vetted.
Yeah, but that was prepared by the town clerk that was here before. All right.
So the decision will be on the agenda for the first meeting in July.
Okay, first of all, I'd like to find out about this payment that you're seeking. How much are you seeking?
You are missing one of it's a page missing because you'll see a payment of $120 and you'll see they received it. You'll see a charge of 150, and you'll see that they received back funds. Then there's a charge of 900, but you don't see what they received that, but you do see the final balance of 780, and that's what has not been received. So it's a page missing. I couldn't determine which page that was. So I'll look at those documents. So in regards for me, I am asking for the 1,170 in legal fees reimbursed to me. The 780 that still is outstanding to the attorney, plus one of the meetings I went to Tallahassee to meet with the attorney and the investigator that saved the town money from having the attorney come here to meet with me. So I'm asking for the reimbursement of the travel there and back and that hotel stay, because I went up that night before. And I do have those documents. So you'll have that all in the first meeting in July.
I would request that you have all those documents together, because trying to find this, I saw a page in here for 120. And I saw another page in here for $780.
That's all.
Yeah. And, providing those documents, would not contend that would be something that would be fully paid, for legal fees or whatever. I have to see the breakdown. I have to
The
see
council will
first.
Oh, okay,
I have
so
to see the whole amount, what you're asking for, because this is just bits and pieces. Can you do it like an invoice type thing so that I can see the whole?
I will make sure you have a
Yes.
one sheet synopsis of it, something.
Yes.
But what you have is how I received it, so I'll leave that the same, but I'll make it clear on one sheet.
Okay, we can do that, that's fine. And then we'll make a decision based upon, we'll make a decision.
And Madam Chair, just because the discussion was started on the CRA side, and I understand that there was some discussion had on the town side. And I just want to make sure, I'm not certain if Attorney Shepherd went through the appropriate case law that governs the reimbursement for legal fees. I know that you talked about the two prongs, but the two prongs is not the only aspect of determining if legal fees should be reimbursed. And based on, and just, I want you to have them to take a look at it just to determine if this is accurate, because if so, it would appear that legal fees cannot be reimbursed. And I'll take you through this analysis real quick, and he needs to understand this, because if he finds that way, he needs to do it the proper way. I hope that it's done the proper way. If he goes to Chavez versus Tampa, which is a second district court of appeals case found at 560 Southern 2nd 1214. It's a 1990 case. And in that case, there was a council member who was investigated by the Ethics Commission also. And what the District Court of Appeals, the second DCA, determined is that the council member could not be reimbursed for their legal fees for a couple of reasons. I'll read that just for y'all in a second. The importance of this coming from the second DCA is because the second DCA, Orlando or Central Florida or Orange County, is unique because it sits between two district courts of appeal. It sits between the second DCA, which is in Lakeland, which I've argued in front of, and it sits between the fifth DCA, which is in Daytona, which I've prepared appellate briefs for. And what it states is that in the case of Chavez, we begin our analysis of this case by examining section 11107 Florida Statutes 1985, the statute under which the appellate claims she is entitled to a reimbursement of her fees. This section contains precise language that fee awards are authorized to defend any civil action arising from a complaint for damages or injuries suffered. The statute clearly contemplates a judicial proceeding in a court of law before a judicial officer by the plain meaning of civil action for damages or injury. It is true that a sworn complaint initiates an administrative proceeding before the commission, but that is not at all the same as a complaint for damages, which initiates a civil proceeding in a court of law as governed by Florida rules of civil procedure. The commission was established in Article 2, Section 8 of the state constitution and Section 112.320 of the statutes as an act to act as a watchdog to guard against abuse of the trust in which officials and employees of the government hold their office and employment. The function of the commission is to receive and investigate complaints of unethical conduct. After investigating, it reports its findings and recommendations Section 112.1.317 dealing with procedure that the commission finds against the respondent itself contemplates that commission's own proceedings do not constitute civil actions. Section 2 of this section provides that upon a finding of a violation of the Code of Ethics and recommendation of a civil penalty or restitution penalty, the Attorney General must bring a civil action in court to recover the recommended penalty. Our reasoning is buttressed by our Supreme Court's finding in Commission on Ethics versus Sullivan, which is found at 489 Southern 2nd 10. That's a Florida Supreme Court case from 1986. That commission is an investigative body and located in the legislative branch of the government, not either the executive or judicial branches. In sum, since the commission is a part of the legislative branch, proceedings before the administrative body cannot be civil actions. Because that is so, the appellate could not be a prevailing party in a civil action for damages so as to activate the statute, even though she was prevailing respondent upon the commission. So what that means is that under the statute, the person cannot receive prevailing party fees, but then it takes it a step further. The appellate claims that she is entitled to reimbursement of her fees and costs under common law theory, even if she is not under the statute. We disagree with this contention as well. The First District Court of Appeal has implicitly held that Section 111.07 supplants the common law, and this appears to us to be correct. Several provisions of Chapter 11 deal with the payments of judgments, settlements, attorney's fees, and costs which can be expended for public officials and employees. See Section 111.065 through 111.072. These sections, when read together with the Code of Ethics in Chapter 112, detailing appropriate public official behavior, address the legal principles previously announced in the area of common law. The conditions that must be satisfied for a public official to compensate for the legal defense is it was done during the commission of their official office and it is a public purpose. So just ask Attorney Shepherd, if you will, to please reconcile this case, because if this case is correct, it stands for the proposition that in a ethics action, since it is not a civil action, that there is no legal fee provision or reimbursement of legal fee provision. So I just want to make sure that he's absolutely accurate with that, and also to take a look at the Florida Supreme Court, which is Thornburg, which is THORNBER versus the city of Fort Walton Beach. That's a Florida Supreme Court case found at 568 Southern 2nd 914, which is a 1990 case also, which stands for the proposition that ethics investigations are not civil actions which trigger a payment or reimbursement of legal fees. So again, I have no position. I just want to make sure that he because it was a part of the information that I provided, I don't think that he took the next step to actually read the cases, because that's what the cases stand for. And I just want to make sure that everything is done appropriate and proper since it was brought to this side and is moving to the town side.
Can we have those documents to be given to the town clerk? So I would like to have a copy of that, please.
Yeah, I brought the cases with me here. I can pass them to the town clerk to.
So you sent an email that said that the attorney should be decided on the town side. He stated that it met the two points and that it would be the council that made the final decision on whether the reimbursements are made or not. But now it sounds like you're fighting against what he has said.
What I'm saying is that since it was brought on this side and I wrote the initial opinion, if he's relying on that and my name comes up as the person that wrote that initial opinion, because I saw the meeting where he relied on what I wrote. I want to make sure that he's fully accurate in what was provided to him. In addition to the two prongs, and again, this is not an issue that I even want to take up. I'm glad it's on the town side.
So he's already spoken on it.
But
Yeah,
but he didn't tell you. He didn't tell you whether.
Call him.
I will call. But I'll provide with the case law, which I thought that you would have read. But the other aspect of it also is that I don't believe that he is. I don't want to get into back and forth with my disagreement with what his position is. So, but I provided the case law that I only ask that for completeness to ensure that things are done the proper way. That he reconciles that. If he sees differently, that's fine. But that's what the case law reads from the second DCA and the Florida Supreme Court.
I have a question. With only two cases, somebody got paid, public officials got paid for getting their reimbursement.
You're acting, but they've been paid for civil cases.
But I'm just saying,
Right, they've been
it
paid for
comes
civil
to,
cases.
I mean, I'm sure one of the, but I'm just saying, I know we had, Mr. Grant got reimbursed it one time, same thing happened with him.
For a civil case, that was a
I don't
civil
know
act.
if it's civil or was it, got this, it's the complaint.
No, I remember it was civil, and that's what I'm saying. The distinction is, and that's why it's so interesting. They make a clear distinction between a civil action and an action that's brought by the Ethics Commission, which is a part of the legislative branch. And because it is part of the legislative branch, it is not a civil action that you can seek either attorney's fees under the prevailing party provision or under 111. And you can't use the common law because the common law is supplanted by the statutory provision. So I just want to make sure that if it comes up that Attorney Jackson wrote this, that is complete and accurate as to everything that the case law says.
So wait, can I just ask one question and I'll let it go? So a civil action, then, and just, if I'm wrong, a civil action is if I take if I take it to court, if I litigate it, it becomes a civil action.
So the court talks about that also, in the second DCA case. This is how it would have worked, unfortunately, this is how it would have worked. Let's say that they would have found, a probable cause, which thankfully they didn't, let's just say that. They say they found probable cause. The Attorney General would have picked up the case and it would have become a civil or a criminal action at that point. When it becomes a civil action, when the Attorney General steps in and moves it into the civil arena, which I'm a former Assistant Attorney General working in the civil division, and I tried cases for the Attorney General's office on the civil side. If it would have taken that turn, it would have been in the civil arena. So again, just make sure that he reads it in that. I just want to make sure that it is complete.
I got it, I understand.
Okay. So clear? Okay, so we can go to the last item. Okay, it's, we have it in front of you. We have it on here as discuss the employment status of the CRA director. And it's the historic town of Edenville CRA wishes to determine the future employment of Ms. Shanika Rose, executive director. Mrs. King, can you read the summary, please? Thank you.
The historic town of Edenville hired Shanika Rose, Miss Shanika Rose, as executive director of the Community Redevelopment Agency, Inc. on January 2nd, 2024. Ms. Rose's 6-month probation period ends on July 2nd, 2024. As looking for the future of the town of Edenville, CRA Inc., the board of directors are required to make decisions in the best interest of the agency and in no way obligated to offer continuous employment for any reason, regardless of the circumstances, at any time on or after the date of a decision rendered by the board of directors.
This came about because we have not been able to get stability on whereabouts of Ms. Rose. It just seems to be misleading board information regarding programs and procedures. One of them is about want some stability on performance. And what I'm saying that is this, there's just been, to me, you all have to make the decision if we want to go ahead and continue employment or what we want to do, because sometimes it gets a little frustrated. And these are some of the things here that I have that I've made a note about. Misleading the board regarding programs and procedures. We had an incident even with the people, the party just left here at 41 Lincoln Street. Okay. Mrs. Mills' name was on the application. She was not eligible to apply. She's not an heir to the property according to, I can't prove that, but I'm going by what was said in the meeting by relatives. If the town would have moved forward at that particular time, we were very close to coming up with an agreement to do the septic tank on that property. And so that was very misleading. And there it goes again, at the time that the application was submitted, there was no background check to determine whether or not her name was on the deeds or whatever. So that means like anyone can come and bring a package, a relative that may live in Chicago or somewhere, and come and want to do some improvements on your property, but they have no authority to do that. So I was very displeased with that. The other one is Tommy Dixon property. That's been emotional, like an emotional roller coaster for the last couple of years. To me, procedures were unclear. People were asking, do you all have a checklist or whatever? I don't know if a checklist was offered. Maybe it was, maybe it wasn't. But when everything was done, Mrs. Rose, you had mentioned to me in June, I think it was around June 5th or whatever time I came to see you, that you all found that it was a gas line on that property. So I don't know whether or not anyone knew that. And at that particular time, we had a contractor pushing down a dwelling, and that could have been, unless it's been disconnected after or before, I'm not too sure, but that could have been a very dissatisfactory, a serious situation. All right, and just tonight, on the PP program, about not really checking the application to make sure everything is complete as it should be. Also, is misleading information that was given to residents in the town about the PP program, because quite a few people asked me about roof. We never discussed or even mentioned roof. We talked about pave, plant, and what is it? And paint. That was in my mind. When a gentleman came in here to the front desk and wanted to know about the program, he saw me in the lobby and he stopped me and he said, well, I come in here because I want to get something done on my roof. He picked up the application and looked at it. He said, oh no, this is not going to help me because I need something on my roof. So we've had just some incorrect information. I think a lot of these programs, they need to be actually looked upon to make sure that we're giving people the right information and we have our checks in order to make sure that we're not giving or receiving false information. Okay, now, also, I have at times in my conversation, I feel like I'm on the defensive. So I'm not too sure it's a personality issue. I feel like I get along with you okay, but at times I feel like I'm being attacked. Also, failure to notify the board chair of your work schedules. Now, that's a problem overall, because first of all, when I had came here to ask for your schedule, I come in the office at times, I go to the back, I don't see anybody there, just like last 3 days, the room is dark. I go out, nobody's here, nobody knows anything, we don't know anything. And then you told me that the mayor was signing off on your work hours. We hired you to work a fair day's pay for a fair day's salary. We don't have work at home policy. We are the board, and you should report to the board. I know you think that the mayor, I know you all have been told that the mayor is the person that can sign off on your hours and all those things, and she can give you time off. But the mayor has not one day came to us as a board to inform us about your work schedule. Not once has she done that. And that's very disrespectful. Cancel a meeting on May 16 without the board's approval. But you didn't notify the chair until you had already canceled it. Okay. Now, also, it's just being very inconsistent here. Also, when the employee of the month, on the same day that you canceled the meeting, I just happened to go to Baylor King to take care of some business. And they told me they were not even aware. They were getting ready to come here for the employee of the month presentation. They had not been notified and was not even aware that the meeting had been canceled. So, it's just those kinds of things. And then stumbling upon all of this, Then come to find out that, we have, corrective action of discipline on behavior in your employment file. So I found it to be very dissatisfactory upon a leader and also an executive that represents the town. So all those things to me is just dissatisfactory. It's the board to decide what they would like to do. And it's just, my recommendation is that, you are on probation until July the 2nd, 2024. And like I say, you have been missing, haven't been coming in, for a whole week, couldn't, no accountability as to where you are, or anybody knows nothing. I didn't even ask. Just come in and check. Nothing. You didn't even call me to let me know. So I'm just assuming that based upon your personal time that you have been spending, on your time, I'm just speculating, maybe a lot of this time was just donated to maybe part of some things that you were doing on your own, personal, for your campaign. Maybe, I don't know. I'm just speculating that because it seems like it's the perfect timing for how all of this, have materialized. Now, I have on here as a recommendation, and I'm gonna read this. The Town of Eatonville Redevelopment Agency Board of Directors to determine employment status. Okay, to extend your probationary period for additional 60 days. The office hours from 8 o'clock a.m. to Monday, 5 o'clock p.m. Monday through Friday, with other hours as needed and changes to be approved by the board. Because you report to the board. So that would be the board's decision, not my decision. It would be the board's decision, on what they feel would be deemed necessary at this point. And, so that's where I am with this. I'm not finished yet. No, I'm not. Okay. So. One second, please. Okay, the other issue that is constantly have a problem that you and I have, disagreed on, and that is you contend that, you are an employee of the town, but you are. But you report to the CRA. I hear all the time, well, the CRA is under the town. And the mayor can sign off on my sheet. She has control over this, that, and the other. That is not true. I'm going to read you something here. And this is not to be a dispute, but it is a difference between both attorneys. We have a legal counsel, which is Attorney Jackson, who represents the CRA. He was hired. And we have Mr. Shepherd, who was hired on the town side. Now, if Mr. Shepherd was hired on the CR side, it wouldn't be a problem going to Mr. Shepherd because he represents the CRA and his agency. But here in his own book, when he did the training with us, it says here, the powers of the mayor and the chair over CRA activities. While the mayor has extensive executive powers over the town government, the mayor has no special direct powers over the Eatonville CRA. The CRA is an independent special district, which is separate, distinct, and independent from the town. It says independent from the town. Even if the town council forms the majority or its entirety of the CRA governing body. As such, the mayor has no direct executive power over the CRA activities unless, and it says unless the CRA governing documents provide otherwise. The CRA is independent because the CRA, we have our own employee identification number. Now, Mr. Shepherd contends that the town is over the employees of the CRA in that respect of the executive director and its agency. We know that the CRA is an agency, but also the fire department is an agency. The police department is an agency. The human resources is an agency. The CRA is not an agency of the town. It's in the town, but it's not under the town. It's self-governing. They have its own governing body, like we're here sitting here today. So I do have an issue with that, and the CRA is accountable to the board. And so I'm gonna let you all talk and you just come up with some things what you feel. And you had mentioned to me today that you didn't feel like I had met with you. According to my reports, I have 45. I wrote down 45 dates that I either sent you information and I talked to you about these particular issues that I have documented. So you can't say that I have not met with you, but I have met with you and I have spoken to you. A lot of days I don't need to meet with you because you don't, if I have to meet with you every day or every week or whatever, but I can say that you have been open to conversations in any emails I have sent. So I just want to make myself clear with that because you made that statement to me today and that was not accurate. Yes,
Gonna go now?
Director?
Yeah, I'm gonna put a level, because you just did. No, I'm sorry. Little contradicting. You said CRA, she was wrote up by the town. So anything was in her personnel file should never been in there because we didn't write her up. The board didn't write her up. That's the first thing that was contradicting on your statement, because you shouldn't talk about that because the board did not recommend her. If you said the town, we separate from the town, they shouldn't have done that. That's the first thing. Tommy Dixon.
Wait a minute, who should have did it? Who should?
Town shouldn't have done it. You just said it yourself.
Absolutely,
You just said it in your statement.
Yes,
That we
yes.
separate and we independent from the town.
Yeah,
But you
that's
looked at
right.
the personnel file, you should said, this was not right. You shouldn't have discussed it. To be honest with you, you should have said, get it, take this out your file. Because we did not do that to her. The board. And you didn't either. So that's never been talked about. Tom Dixon probably had a septic tank on it too. We didn't know that. I don't think she knew that. Nobody else probably knew they had a septic tank. It was septic tank on that property. In recreational program, probably do roofs, but the PPP thing don't do roofs on any properties. So someone asked me about that today. About do they do roof? I said, no, we don't do roofs because we don't know how you collected money on your insurance one time, you didn't get it fixed. So that's a whole big thing there. But on the other hand, congratulations, Ms. Rose, on your election. Let us know what you want to do in the future for the town of Hill. If you go forward or with your plans, you will do because like I said, she said, you're not here. Do you want to be here? What? So let us know what you want to do. That's what I would say.
Okay, well, I'm gonna go ahead and speak now, if you're finished, if I can, Chair.
Yes, sir.
Okay, I'm Ms. Rose, I wasn't a part of the hiring process. You got hired initially for the CRA Executive Director. I think if I was, you probably wouldn't be sitting in that seat right now. And I will say this right here, according to everything that I've experienced with you as an executive director, has been anything under professional. I have to say that honestly. I've actually got emails from you with you stating that you want me to refrain from being condescending and passive when it comes to speaking with you. For one, I would never call you and be condescending or passive, or not passive, but aggressive. My thing is, as a board and as a director, what I did that day is I called you and I simply requested, could you please, I'm asking this as a request, could you please kind of like, get with the board and see if we can put a hold to the property, the Tommy Dixon property, until we can better decide on, even though we know we passed it with getting a demo, but I came up with an idea that I think would have been great for the community as far as the police center. Not necessarily a police substation, but a police center. And I know according to the grant that we had, they indicated that it had to be new. But I wanted to have a discussion with this board while we could move forward with speaking to the grant itself to see if we can come up with some kind of solution to have the structure that's already there and add on to it, which would have made more sense. Especially with the amount of money that we got to particularly add to that particular project once we do move forward with doing it. But not only that, I never received any emails back from you whenever I sent emails out. Now, to me, that's insubordinate. If you ask me personally, because if, especially in a timely manner, I gave you a timely manner to even, wrap your head around, okay, should I email him back or should I not? You didn't email me back. And you definitely didn't do it in a timely manner. And I had to, actually, ask you in a meeting, the last meeting we had, could you please email each one of us back when we email you? You don't, you gotta remember, Ms. Rose, you work for this board. We don't work for you. You understand that? So I feel very disrespected by you doing that also. And not only that, I haven't met with you alone since I've made those comments because I don't feel comfortable meeting with you. I really don't. I don't trust you. I think you're unprofessional. I don't think you meet the criteria. I don't think you're qualified to even hold that seat that you're sitting in right now. And like I said, I had no part of the hiring as an executive director. And also, I never went to the point of even asking to look at your files, but I will moving forward. I will moving forward. I promise you. See if it's anything within your files that meet everything that you said that you're qualified to do as an executive director. Okay. Now, also, your calendar is something that I'm very interested in also because I know you just recently had the election and like board member Washington said, congratulations, you know what I'm saying, on winning your race. But in any event, if you're working as an executive director for this board in this town, as a CRA director, we need you present. I know I got another job that I participated in, but I meet all the criteria that make me be at my job when I need to be at my job, as far as serving on this board also. So I'm definitely holding you accountable and responsible for your duties as an executive director, regardless of what are you doing. Whatever you're doing, that's your own personal business, right? So I would definitely like to look at your calendar. And I did read an email from a resident that I was kind of blown away from, to be honest with you, because if it is true, and my thoughts and my train of thoughts right now is definitely doing a full investigation on these matters to make sure that we are lining up on what we need to do. And this is to protect you, to be honest with you, Ms. Rose. Listen, anytime you're not getting feedback when you're asking very serious questions in terms of, I asked you through email, Ms. Rose, could you please give me, and I think I copied on the clerk, could you please give me the environmental studies on the Thomas Dixon property? Because I feel like there's something that we need to really look into before demolishing this property, because we got a daycare, and not only the daycare, you got residents that live within the grounds of this particular project that we tore down. Now, if a gas line would have broke, we would have had asbestos or anything of that nature to harm this community, I would have been holding you liable for that. And I'm still holding you liable for it because you never responded to my email in terms of giving me the environmental studies on that. And I think that is very problematic, especially you being an executive director of this CRA. I think it's very problematic. And I still have a problem with that because I've yet to even receive an email from you regarding, well, let me take that back. I did, but you told me, well, Attorney Jackson, I think, told me according to the environmental study, you're piggybacking on what Orange County does. Listen, we're in Orange County, but it's procedures that need to be done because the procedure that was done down here at Heroes, or the old building of Heroes, you did an environmental study on that, but you couldn't give me an environmental study on the Thomas Dixon property. I'm not understanding. So you're being selective on what you do. You can't do that as an executive director, not working for any entity, any town. I don't care who you're working for. And I'm almost done. Now, me personally, like I said, I haven't had an opportunity to look through your files because I gave you the benefit of the doubt when I initially met you. And I felt like you was a very nice person when I first met you, but that soon had changed because of the direction that you've been going in and the it's more than I think you've been giving me. And I've been being quiet about it because I don't wear my feelings on my sleeve. I don't, and I respect you as a woman. I do. I really do. But the attitude and aggression and the unprofessionalism that you've been giving me, I'm definitely not satisfied with. I can assure you that right now. And for you to sit here as an executive director, me now, I can only speak for me. I don't think you're duly qualified to serve the purpose of sitting in that seat that you're sitting in right now. And like I said before, I wasn't the one that was a part of the hiring process of it. Because like I told you a few minutes ago, and I'm telling you now, if I was, you would not be sitting in that seat. I can almost assure you, because of probably the resume or what have you, showing that you're not qualified to serve that seat. Because it takes it takes a, and like I said, I'm not taking anything from anybody, but to serve as a director, executive director, it takes a lot. It takes a lot of experience. It takes the ability to be professional, not just the experience in being an executive director, but you got to be professional as being a director. No matter how you feel about any individual up here, you got to be professional about returning emails timely or just returning emails. I didn't even get returns on things that I have to, make sure that I'm making sure that I'm lining up with, because you're making my job difficult. Not only because you're not returning email that I definitely need, but you're also putting me in a position that I didn't even want to meet with you because I feel totally uncomfortable meeting with you because I don't trust you. And anybody that you can't trust in your workplace, and it's an environment that is very hostile. And I know this is not the first time that you're hearing all these things that I'm saying, because it kind of struck me by surprise when I heard it from other individuals, especially you being reprimanded by someone that you shouldn't have been reprimanded by. If anybody should have been reprimanded by it, it should have been his board, an entire board, instead of one individual. But I'm glad it was brought to her attention with the things that you've been doing and being reprimanded. So that kind of states my, state on what I'm doing right now, Ms. Rose. And then also, my opinion, I know we have an opinion to extend it for 60 days, which I'm in favor for. See, that just tell you how unbiased I am. Because everything that is happening right now, I still give people the benefit of the doubt that they can change. I feel like, everybody deserves a second chance. I told you I got tough skin. Being an elected official, which you are at this moment because you just actually won your race, it's a tough job up here. As directors, as an elected official, making educated decisions that's going to be for the betterment of this community. And I know we got programs that can help you if you seek those programs to be a better director, to have a better attitude when you're dealing with not just us, but the citizens, the community, when you're out here dealing with any and everybody. Those are the criteria that we expect from you. Now, if I was a director and you was the person as an applicant, I would have interviewed myself. That's what I do to every director that sits up there since I've been sitting on this panel in the past. I would have interviewed you myself. And I put that magnifying glass on to make sure that I'm dotting my I's and I'm crossing my T's, that this young lady or young man is the person that we need to sit in this particular seat that you're sitting in. Because that's a very important seat that you're sitting in. And we rely on you to sit in that seat and give us information that we need. I don't need you to sit in that seat and ignore emails and go through the whole point of just disregarding everything this board says. We don't need that. But in closing, I'm in favor of doing the 60-day extension. I'm not in the I'm not in the business of just giving up on people. And that's just how much faith I got in people itself, man. But in that closing, that's my whole spiel. Let's extend the 60 days if this board wants to.
Okay.
And that's all I got.
Appreciate board member.
Okay. If we can, I would like the procedure to be, changed. Problem I had with, executive director is that when that meeting, that special meeting that was called in May, I work in the morning, so I don't have my town phone with me. When I saw the email saying that there was a special meeting, I was like, what and how? I wasn't polled or asked what was going on. I had an opportunity to go on my company's email, to check my town, and I didn't see anything. So I think I reached out to Ms. Rose, the executive director, and she said I called. So I said, okay, when I get home, I give her the benefit of the doubt saying that she called. She called, but no one left a message saying we want to pull you for an emergency meeting or anything. I felt disenfranchised because being on this board, at least say, I'm gonna leave you the email or leave you a voicemail to say, hey, board member James, we're trying to schedule this meeting. Can I see where you are or what you got going on before we even plan the meeting? I felt disrespected, but I'll let it slide. So I'm all about fixing it. So I would say, let's let the clerk do it from now on, because every clerk in the past has called my town phone and has left an email saying, hey, we would like to boom, 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 boom. And before the process was done, a meeting was set, they got my vote, or they got my, hey, are you available? Are you da-da-da, before the meeting was planned. So I'm not here to bash me or say, let's correct the problem. Let's give when we have special meetings or polls or whatever, let's give it to the clerk and let them be in charge of calling us, leaving emails, and not just, just call it and say, I call you, and without even, I really felt disenfranchised and disrespected as well. And that's all I had.
Okay. Do you want to speak?
Okay. You ready? Okay, well, I want to say that I feel completely opposite. I think that this board is aware of directors in the past that have been complete bulldogs in communication. And I think when we start saying things like nice and kind, we are saying those to females. Because I know a director that was not a female, and they stated just what was on their mind. And we did not say write them up, and we didn't use this same terminology, and this is me talking. So there's a double standard being used right now. Secondly, the board had approved the tearing down of that building. And if the board approved it, there really was nothing else individual should have said against what the board had approved on that property. And I believe there is more going on there. And if you remember, the director had another contractor to do that job. And this board wanted town people or someone associated with the town, which by all rights, that was great. That was no problem. However, the experience levels were different. And had the other contractor gotten the job, then it might have looked totally different. That is not her fault. In regards to environmentals are usually done on commercial properties, number one. Number two, with those grants, not just that grant, but even if we would have purchased the hotel, they would have required the environmental. So if in the future we want environmentals when a residential home is torn down, then we'll have to get it for anybody that wants to tear down a residential property in the town and make that one of the requirements. It wasn't a requirement. The PPP program that was brought to the board. If the board did not want the roof as a part of that, the board could have said no. And I think in that discussion, and here's the other thing, if I'm a citizen and I pick up that application and I say, oh, it doesn't say roof here, but I really need that roof. So I'm gonna go ahead and put it on there. They say no, they say no. Why is the director could have said, no, we're not going to do that, or the director could have said, the board needs to approve it. And that's what happened. It came for the board, we approved it. That cannot be on her now. Because you have the opportunity to say no to that. But it was discussed in the future that we look at changing that. Since COVID, work schedules don't look the same. And are we are we gonna be helicopter? What do you call it? Hovering over individuals. When you supervise, you don't supervise individuals, you supervise the work that is being done. And if I'm not mistaken, and please be very clear with the board on the last. First of all, thank you for the work that you helped with the museum. That took a lot of time and effort to keep that coordination. And that's the town working with the CRA. I think that's one of the problems too. The town and the CRA have been going at it like this, but they should be working together. I, as mayor, do not see the town over the CRA. And the things that are on this agenda, it's not mayor driven. It's not mayor driven. And no one here can say it is. So don't, and rather I sign that payroll that goes through human resources that's on the town side, or you want to do it in the future, that's fine. That's fine. You do the payroll. I mean, that's fine. That's fine. So that's no big deal. Again, don't blame the director for that. Corrective action. Do you mind me stating that was two personalities clashing? We have seen that in every workplace in America. Two personalities clashing. Corrective action. Hey, just look at this video so you know how to kind of solve a problem. Sometimes you get heated in the moment. You should have been more concerned that nothing was there. You should have been okay that even if you thought that was a CRA action or whether it was a town action, that action was taken to make certain that the internal workings of this agency continues and that we're not being subjective. That if we expect you to work with me and me to work with you, then we expect that across the board. So you should have been more concerned if nothing was there, because that was something and it helps build character and it helps build staff. And as with the new election, I see that as a plus for this. What you learn on that commission board, some of those things that are happening there, they're going to benefit us. So I see it as a plus. And I hope that you don't want it. And I hope that we stop this. I don't want you, I want somebody else. So I'm gonna put a bunch of stuff on this list and I'm gonna ask them to fire you. Let's stop that nonsense. Let's stop that nonsense. And just I wrote notes as we're going. And I think the gas was turned off on that property because that was mentioned. And some of the things that we have somewhat attacked this director for, we didn't say a word with that last one. And that's my friend. We didn't say a word with the last one. And now would you tell us about the latest grant? Because rather, I don't care if you're working on a rooftop. If you're doing things that's going to help this town and it's going to be better for this town, it shouldn't matter if you're hearing this off, because sometimes when you leave, some of the best ideas happen when you're sitting at home, you're relaxed. You know, and COVID changed the way we should see the workplace. We need to get with it. But I think right now it's a way for us to check another box as to why we should be negative right now. And that's not a box to check. It's not a box to check. Please explain the last grant that you were able to.
So there are two things. We were approved through a grant to redo trees along East Kennedy. And the bigger one is that we were approved for $447,880 to redo the CRA building to create a business incubator space.
The work that was put into that grant, did it happen in an 8 to 5 day? Or did you have to do some of that outside of your office hours?
Outside, because some of the things in the typical world, CDBG, some of the things that were included in CDBG were not, and I had to advocate why from the county, from this town perspective, why the county should support.
And I see even with some of the emails you see the time, it's not within an 8 to 5 window. I mean, we could do that. We could do that. So I hope that this board does not move forward, not even with the extension of a probation, because people should be able to start earning their time off. But the probation should end July 2nd. That's how I feel.
If I can add, Chair, just one thing and then we'll let you. See, this is one of the main reasons, I think we definitely need to, I know we can't go independently, as a board. And I can, appreciate the laws that, support that. But moving forward, I think this is why we definitely need to do the separation with CRA and town business. This is exactly why. Everybody's gonna have their own opinion on how they look at things. You may not have the same experience I had when dealing with the executive director. So that's gonna be your opinion, lucky you. But, I think, moving forward, like I stated to her, I do believe in giving people opportunities to change. You know what I'm saying? I think, change is good, and I think anybody can change. So I'm hoping and praying that she could get to a point of changing the way that she's operated in the past, especially being a elected official right now. So, but anyways, I'm gonna let this board decide on how we're gonna vote on this. My opinion is definitely to extend the 60 days, and that's my opinion.
Just talk to that, hey, hurry up, talk.
What's that?
I have,
Yeah, I'm done.
okay, Attorney Jackson, no, first of all, I'd like to ask Mrs. Rose. Mrs. Rose, if you're in a good position, how is that gonna affect your work schedule here at the town as executive director?
I haven't gotten into the role yet, and so that's the.
Yep. But you do have an idea as to what you want to do, you know? Okay, but then you should report to 8 to 5, Monday through Friday. Okay, also, what I am, want to ask Mr. Jackson, is there anything according to the statutes or not violation laws, that, you can work for 2 municipalities? You can still work for 2 municipalities.
So,
Yeah, in this
Well, no,
particular
one
case,
is
it's
an
separate, yes, ma'am.
one is an employee,
Yes,
so
ma'am.
I guess that would be permissible.
Yes, ma'am. And it's frequently done, yes, ma'am.
Yeah.
I work for Orlando.
I do.
Yeah.
I work for Orlando and.
Yeah. Okay, I just want to make sure that we understand that you do have a work schedule, from 8 to 5, and you should be here Monday through Friday. So if you have anything any different, this is the time now while we're at this meeting to make it known.
So I'm gonna say, because that's not fair what you just did.
No, it is fair.
Well, no, let me speak. It's not until the board makes a decision.
We're gonna do that. You just haven't given me an opportunity.
No, you just stated to her.
I said, I'm gonna put a motion on the floor,
But you don't have that on the agenda.
Okay.
but you don't have to.
You just said Tuesday, you do it in decent and in order. But that's fine.
Yeah,
That's fine,
We are
Chair.
doing it decent. and
That's fine, Chair.
I thought we just on discussion, anything.
That's ain't no discussion.
I
Well,
thought it was discussion.
It's all discussion.
okay. Well, you know what? I'll leave it as a discussion.
well, I'm just saying, Attorney Jackson,
Do we have to leave it as a discussion? Attorney? Or can I put a motion on the floor?
My recommendation, is that before taking an action, I don't know if Ms. Rose has an employment contract with the agency or not. If so, then I think that we should operate off the provisions of her contract as to how it would be done. If she doesn't have a contract, I would probably recommend and suggest that she does want to protect herself, as well as the agency. My position has always been, I know that there are varying opinions on this. My position has always been that if an item is on the agenda as a discussion item, then it is a discussion item. This board can do what it pleases though. But my position is, and I've always maintained this, and I understand that others have done different things. My position is that if it is a discussion item as of tonight, to treat it as such, but this board can proceed as it wishes.
so it's not unlawful. Basically,
I'm sorry.
it's not unlawful to do what we're doing.
It's
If
not-
that's what we choose to do.
it is not unlawful.
Okay,
I'm
so-
not gonna say it's unlawful. I can't say that.
So what, I'm just saying, you're telling me that this board can do whatever they wish, and then on the other side, you're telling me you're not gonna answer the question in terms of if you don't know if it's unlawful or not.
I just said, it's not a law. I'm saying it's not a law.
Oh, okay.
Yeah, I just said that, so it's not a law.
Okay,
What I will say is that from a notice provision, however, to give someone a fair opportunity to know what's taking place from a notice aspect, I say that more so from a best practices aspect.
Well,
not the legal part.
my reason for the particular, and I think it was a great idea to move forward with doing the extra 60 days because of everything that I've experienced. Now, that's just my opinion. Now, like I said, everybody is entitled to whatever opinion they want, and certain people didn't experience what I experienced. And like I said, good for you guys, but I did. And I think to protect her and to protect this board, extend it for another 60 days. Now, that's just my opinion. Now, if, wins or not, or drops, I don't know. Whatever the opinion of this board here, I think we're gonna be the one that make the ultimate decision on how we do it. And hope that you guys could see it as a protection for everybody, especially her. You know what I'm saying? Because this is probation is probation. And if we're entitled to, extend it for another 60 days, especially with the particular behavior that we've been experiencing with her, with us being behind the 8 ball and having it so hard for me to do my job, I do see a reason for us to extend the extension, the 60-day extension. It just makes sense to me. That's just my opinion, guys. Like I said, I'm only one vote.
Yeah, okay, I got you. I heard you. Yes.
I just wanted to say that, congratulations on, being elected. And, to piggyback off of some things that were said earlier, specifically individual experiences. I've had an extremely professional experience with you. I think, I know I don't bother you much. I don't ask for much. If I do need to get in contact with you, it's not been difficult for me. I think you have a harder time getting in touch with me than I do with you. And so I want to say thank you for your flexibility. To piggyback off of what Director Gardner said, we are in a different kind of space post-COVID. And I wanted to speak on that as a stay-at-home mom. And I know that most of the directors on the board are past this 2-year-old stage that I'm in right now. But I can appreciate the flexibility of being able to work from home. Now, again, this has been the personal experience that I have had with the executive director, where if I did need to get in touch with her, it was easier for me to do it from the comfort of my home. I didn't have to come to the CRA building, load up my crumb snatchers, drag them on down there with me. She has been extremely flexible. And again, like Board Member Max said, this has just been my experience. She has been subject to flashing lights in the background of a Zoom call and screaming babies throwing snacks in a Zoom call meeting just to accommodate being able to meet with me. Like Board Member Max said, I'm sorry if that wasn't your experience. I just want to put on the record that I've had a professional experience with her. I cannot speak to what happens or what she does or what she says when she's not in front of me. I can only speak to my own receipts per se. I do also understand Board Member Max's position, maybe even Vice Chair Williams' position, having been newly reappointed to the board and having only spent a portion of the time that she's been employed with her. And how, it might not have been as long as some of the rest of us, but in the 6 months that I did get to interview you individually, I did get a chance to sit with you and talk with you, review some of your previous experiences, what you bring to this board, what kind of asset you could be. And so personally, I am currently appreciative. I do wish you well in making a decision, balancing out, your new role in addition to what you do here for us at the town. And hopefully this is something that I do understand, of course, your position, Director Mack, about extending potentially that probationary period. I do also agree with Director Gardner that it could potentially be seen as unfair if you have been told at one point upon hiring that the probationary period would be 6 months. You have that expectation at the end of those 6 months. In the eye of doing things professionally and properly, if that 6-month period is scheduled to end at a certain time and the board does not see fit to move in a different direction, then I am with the majority. In ending that probation period when it's set to end, should it be the board's wishes. If they desire to move in a different position, then you know where I stand. Thank you.
Okay, Board Member Williams.
My only thing is, I'm big on education, especially for our people. I'm always telling you, educate yourself so you can educate others, whether it's here or in your current district. That's big. Far as our relationship, I ain't really had no, we talk, whatever, email, you pretty responsive to me and what have you. I don't have no problem. I just want us to clean our house up so we can move forward. Because the CRA been around for 10 years since '97. And I look around, I ask, what have we done as a CRA? We coming to a possible extinction. What do we have to show? You know what I mean? So we need to do our due diligence of putting our footprint on this community and say, hey, we accomplished something. And rather sitting here just for saying, I feel like sometimes waste the time, because we gotta do some things. That's why I'm here. We need to do some things. I think if we show consistent of good faith as we are going in the right direction, I do believe we will get an extension program. You better at least gotta take this step as far as putting stuff out there saying, getting the community involved and whatnot. I want to say this to you, Ms. Rose, get your advisory board, let people be involved. That's essential. I think sometimes they may hear, people may feel disconnected because there's nobody, but they don't have, they feel like they don't have a voice. That's not good, especially when the whole district of the town is the district. I'm just gonna say that to you, but as far as moving forward, it's a unique situation with what just happened with you being elected as a city commissioner. I'm gonna suggest we do have an additional period for probation, because you don't know what's gonna happen. You don't know, you know what I'm saying? So, in your district, it's a tough district. You have a lot to deal with. You're gonna have to deal with the different venues in your district and whatever comes from that. It's gonna be a challenge. But in a way that we can help, I can help. Let me know. I'd be more than happy to. I'm saying along with but like I said, you're going into something new. I wish you the best, and that's wonderful.
Okay. Well, I thank everyone tonight. As far as this issue is concerned, we'll just, what I would do is, I'll just wait until either the next meeting or if I feel necessary that we need to call a special meeting for whatever reason to handle whatever needs to be done in the best interest of the CRA. I will make sure that you get the information and that you will be polled if it's necessary. If not, then we'll just address this at the next meeting if possible.
So
Any
sorry
changes?
to cut you off. I just read that her probation's over with at
July
July 2nd. The meeting is after that, so are we having a meeting before then?
There's no need to try to have a special meeting.
Special meeting too.
I will let
Let's
everyone
ask.
know.
Okay.
I will let everyone know. If we decide, we may not, we don't know. I don't know. Okay, this is special. But I leave it here.
I think the best educated decision to do is, like I said, vote it up or down. If she gets the 60-day probation, if she don't, gotta have, I don't wanna sit here and continue going down the path of having a special meeting for something that we can resolve right now. That's killing the town's money. As far as, the funding for this particular meeting, and then that's just taken away from us having to come back here and do the same thing that we can do right now. We gotta make it make sense. You know what I'm saying? Like I said, if we're gonna sit up here, we gotta make educated decisions for this town, not sit up here and, say, oh, let's do a special meeting. Why? What is that gonna be, a couple of days? Cause you got, listen, it's the 20th already. Make it make sense.
It was already said that this was a discussion.
But you put a motion, you put a motion on the floor.
No, I didn't put a motion on the floor.
I thought you put a motion on the
No,
floor.
no, it wasn't a motion.
Okay, but like I said, like, Tony said, this is something that you can do. It's not unlawful, right? So if you can do it and it's not unlawful, won't you proceed on doing what you need to do right now as a board and vote it up or down? Simple. If the vote goes up, it goes up. If it go down, it go down, and we be done with it. And they ain't gotta come back here in a couple of days. Seriously.
Well, right now, I think we said it was gonna be a discussion, so I really just go ahead and stick to what we agreed upon. If there be any changes, we'll let you know.
If you want, what, 6 more days too?
Any other changes, we'll let you know. Okay, all right, thank you.
We're gonna let Ms. Rose speak, or?
Yes, I'm gonna speak.
No, okay, I did, I'm sorry.
Okay, on the agenda, what is next? Is that it?
Reports.
Okay.
No sports.
Yes, ma'am. Just real quick, I want to publicly, congratulate you both on your recent election. The other thing also, just for the benefit of Ms. Rose, as well as to protect, this board, my recommendation is that she does, if she doesn't have one, to get an employment contract. I was actually just looking at the employment contract for Mr. Benson, which I did help to negotiate and to draft. And then within his contract back in 2016, he actually had it contracted that he would work 12 hours from home. And I believe Vice Chair Williams may remember that, because up to the time period he was on the board, as well as Board Member Daniels. He also had in there that he would be able to work outside of the office as well. So in order for the board to know what's taking place to protect both parties, I think that it would be important to have an agreement in place.
Director Garza.
Question, do you remember how much the pipes were for that sewer? Was it 700
For,
to fix that pipe?
oh, the septic was 2,200.
Okay, so, we can't, and this has been discussed before, I'm not gonna rehash it, but we can't go on that property without the owners. We can't. This goes beyond who signed that application, but I do believe that at the minimum, that the heir should at least do the application. I'm not gonna rehash any conversations, except the fact that if there's an executor of that will, they've already been identified as the executor by what you stated Tuesday night and what they stated. So those two things y'all agree with. And an executor has been identified, and that's their job. That's their job when it's not clear who owns the property. They execute. And if they're the executor, if I'm not mistaken, attorney, can the executor make a how do you have an executor as executor if you have someone still living that's on there on the
Yeah, an executor basically makes sure that the wishes inside of the will are executed and done, and that any
We haven't done
wait,
that
no,
in
please.
years.
I'm trying to work it out, please.
And that if there are any debts that have to be paid, they make sure they reconcile those things. If there are any beneficiaries or heirs, they make sure that they get whatever is entitled to them per will.
What about the taking care of the property and making decisions on the care of the property?
The executor in the absence of a personal representative of the estate, because you can also have a personal representative of the estate assigned. In the absence of the personal representative of the estate, then the executor can act in that fashion.
So here's what I'm saying, because first you get, this is what I said the last meeting. You get approval from whoever has the approval to give the approval. Hold harmless for the town to extend the pipe to the road. If it's $2,200, but that's about August, September of the pay that I received as mayor, I will forfeit that pay for this to be done with. And then if there, whatever's after that August, September pay, then that should be something that can be handled. But nothing, no laws or anything like that is to be broken. And it has to be clear approval from the person that has the right to make that decision. So we be done with it. I'm sorry,
Go ahead.
Chair, someone
I
asked
was
a
gonna
question.
say, whatever she does with her money, that's on you, but I don't think that's your part of the town, so.
It's not
whatever-
it's my.
That's what I'm saying, whatever you do on yours is
Yeah.
you, that's what I'm saying.
Yeah,
Because we tried to do that
One
from,
second, one second,
we
we
tried to
still
do
in
that
session.
before, and I think legal said that whatever you do on the outside, you just can't, bring it up here, saying what you're doing, you know what I mean? You can, whatever
But
you do
the
on the
application,
outside,
see, I see what you're saying.
Right.
Yeah, but the application, still comes, I see what you're saying. Got it, I see what you're
But
saying.
the town need to do the due diligence. Put the ladder, go in and put the sewer on their property. That's what need to be done first. The town, not from the house to the pipe. The road to their property line need to be done first. Okay, they're not paying anything, but that's what we're here for. Town need to make money when they sewer, they don't stop paying sewer. So we need to get the line tied to their property. And from there on, that's on property owner. From there, that's what you volunteer to do. So the time to do their job, to put them.
But if I can say this, according to what, board member, Gardner said, now, if she's gonna come out of her own pocket, whatever, but I just wanna say this, it's a grant that's out there. So if we're gonna get the permission from the person that we need to get permission for, the grant is available. So why would she have to pay anything? You understand me? So if we can do that, I think that'd be a lot better and that'd be a lot less strenuous for anybody to come out of their pocket. You know what I'm saying? Because if I could do it, I would do it, you know what I'm saying? But if we have a grant available and it's not saying that we can't do it, why not do it? If we get the permission from the people that we need to get the permission from. So it just makes sense to me. If we can get the people that could approve this and say, you know what, I'll do it. I think this board would be more happy to say, you know what, give them the $4,900 to fix the issue.
You're right.
So
Either way, we gotta get approval from the people that have.
now you gotta get the approval though from the executive
Okay,
people that.
excuse me, can we move on?
All right.
Everyone has had their question. You want to speak? Okay. Yeah, I have no report. Okay.
I have no question. I think you scared me. I really just have a question. I'm ready. My question is in regards to the work being done in the median, out here on Kennedy. I know we had discussion and y'all help me. I'm having a brain fart tonight. Okay, so that has nothing to do with what we were discussing. Okay, because I saw the work being done. It's pretty. I just wanted to know if that was, yeah, okay, and I saw the signs out there, so I thought it looked nice. I wanted to say as much. I just didn't know if that was part of our CRA work or not. Okay. Good job, Tam.
Motion to adjourn.
So moved.
Okay.
Even though you're scared, so.
Put my tooth roll in, y'all. Yeah, yeah,